Call the matter of Caleb Baker. Is that you?
Yes, Your Honor.
Did you stick your finger into an electric socket?
I was in a hurry. I didn't want to be late. I wasn't late.
I wish I had hair on the top of my head, though. Now that you're reminding me. Okay. Earlier, the defendant entered a plea to aggravated assault, a first-degree felony. A pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
I've reviewed it, Your Honor. I don't do particular corrections.
None from the state judge?
This made a part of the record for all purposes. Is the complainant here, the victim here?
No, Your Honor. Nothing I'm aware of.
Well, I got a problem here. He says the defendant has a version. I've read that.
Yes.
And then contact was made with the victim who strongly objects to the defendant receiving probation.
Yes, sir.
He advised he has not been notified of the status of this case until this statement.
He was before that because we talked about it right before I made the offer. He just doesn't want him getting probation, wants him to get pen time.
Well, I mean, he says the defendant tried to kill him. He shot over 5 rounds on purpose. He tried to kill me. And he's pretty sensitive about that. Meanwhile, the defendant says it was all the victim's fault.
He's not saying it's all.
You were,
Okay. I disagree. He's contextual.
Let's read this together.
He's
No, let's read this here.
He's not
Defendant's
saying it's
version.
all.
I picked up my wife from work. We were coming down MLK in Franklin and there was a vehicle with its hazards on. I had my blinker on to get over to the next lane. When I started to move over, I did not see a speeding car coming and all I heard was screeching tires. After I slammed on my brakes, the victim pulled up next to my car and started screaming and yelling at my wife, kids, and me. The victim stated, "You are lucky you have those kids in the car. I'll air this bitch out." We kept driving and he followed us. I saw a red laser pointing at us and I took off. The victim pointed the laser again and turned on the feeder road. I turned on the feeder as well. And that's when I pointed my gun and shot at him.
Right. He's not saying, he knows he's at fault here.
Oh, it sounds like self-defense,
No.
doesn't it to you?
But it's not deadly force. A laser.
Well, why did you? Oh,
He's not justified. He wasn't justified in what he did.
I don't understand. I don't understand this. You're trying to take sides on this, both sides.
No.
Are you the victim or not?
No.
Are you the victim or not?
He's looking at, hey, you're not a victim.
He wasn't at the scene. You were the one at the scene. Were you defending yourself?
What were you, what,
Yes, I was defending me and my family.
from a laser point?
I don't know exactly what it was. I mean,
Victim input matters a lot at sentencing, especially in violent felonies. The judge is basically saying, I've got 2 narratives, and the victim is furious. And when a victim says no probation, that doesn't automatically control the outcome, but it absolutely cranks the temperature in the room.
yeah.
Well, he may think in his mind, Your Honor, but from a legal standpoint, I think for self-defense, he used deadly force. It would have to be in response to deadly force. I don't know that what the co-actor did rises to the level of unlawful use of deadly force. He would be entitled to get a jury instruction on self-defense. So he's not obviously an expert on the law of self-defense, but in his mind, he knows he was acting inappropriately when he shot at the guy.
Okay.
I mean, there's no question about that. Right, Mr. Baker?
Right.
And if you look at his criminal history, I mean, it's not extensive. It doesn't, it's not like he has an extensive history of any kind of violent related offenses.
I've done this long enough to know, to see. You got 2 different stories here. And he thinks,
He thinks it's better to plead to try to get the probation versus going to a jury for a decision, Your Honor. Yes. And you can speak to the court. I think he's extremely remorseful about this. He's been away from his family for 4 months because of this stupid decision. But it's
Yes.
contextualized. I mean, there's context here. He's not just some maniac driving around the road shooting people. That's not what happened.
Deadly force has rules. If all you've got is a laser and you think it might be a gun, that's tricky. Courts often look for, did you actually see a weapon? Did you have a safe way to leave? And did you escalate when you could have disengaged?
I mean, it happened that he shot at somebody because there's a context to that. There's two people here doing things on the roads, and he's not operating as vacuum where I'm randomly shooting at cars.
Well, he's gonna shoot every time he sees a red laser pointing.
No, I think that he's learned.
Oh, that's what he's done. That's what he says that's why he did. I saw a red laser pointing at us and I took off.
After
The
the
victim,
I'm sorry.
What?
you left the controller.
The guy threatened me.
The victim pointed the laser again and turned on the feeder way. I turned on the feeder world as well. And that's when I pointed my gun and shot him.
He had been threatened by him. It wasn't just a laser shot. There was words exchanged. He was threatened. That's actually a situation. Again, I don't think he was going to do this again. He's learned his lesson. But he had his family with him. And he was scared and he acted inappropriately. I mean, that's what the PSI addresses there through anger management and moral recognition.
I think that
Recognition, then these things can be addressed in a remedial context versus putting them in.
So what about the victim who strongly objects to him receiving probation? Honestly, because of the severity of the situation, he tried to kill me. He shot over 5 rounds on purpose.
Well, Your
No
Honor,
regard for my own family or anyone else. That seems serious.
I would say that it's the state's case and the state's decision, Your Honor. Obviously, the court takes into consideration what victims express desire, but I'm reminded on many times when I have uncooperative victims who want to drop cases that the state reminds me that it's the state's case and not the victim's case. So that's looking at the totality of the circumstances.
It is.
We have to do.
But since one of the victims not have a board.
No.
They do, but they should.
Okay.
But this is not some
Okay.
pristine victim. It's not-
What's state asking?
Well, I'm asking for pen time, the 6 years pen time on the 6-year cap. And I think that last sentence in the defendant's statement is what turns the whole thing. When it says he pointed the laser again, it says he turned off on a feeder road, and then the defendant turned off on a feeder road and followed him, and that's when he shot at him. Because the guy was veering off and he shouldn't have gone after him and shot him. That's what gets him pen time.
Well, do you want to address it, Mr. Hagan? What happened?
Start from,
Tell the judge, tell me.
so start from the beginning.
Yes.
So start from the beginning, I had, me and my wife and my 3 kids, my 7-year-old son and my 5-year-old daughter and my 2-year-old daughter. We were coming down MLK Street. We got to the light, the hill before, Franklin and MLK Street. And, there was a car that was in front of us with their hazards on. And I had my left blinker on to get over in the lane next to them so I can pass them up. And I didn't see the car coming down the hill so fast. I don't know how fast he was going, but he wasn't going fast. All I heard was screeching of tires. And that's whenever I slammed on my brakes, thinking that somebody was coming through the light on Franklin. So I kept on going after I realized that nobody was on the side that was coming to hit us or whatnot. So the guy, as soon as we passed the light on Franklin and MLK, going northbound toward the north end of Beaumont, he pulled on the side of us and was yelling at me, my wife, and kids. And he was looking around in my vehicle and he seen my kids were in the vehicle. And he said, "You're lucky you got the kids in your car. I hear this, excuse my language, bitch out."
What do you think that meant?
To shoot my car, kids don't like him.
What happened?
So what did he do? What did you do when he pulled the gun out at you?
So
Did you see the gun pointed at you?
I've seen
Did you
some-
see the gun pointed at you?
not technically, no, sir.
Not technically. You know, you mean by
Yes, I mean.
clairvoyance? What? But imagination?
It was in the shape of a gun. I don't know if it was an actual gun, but it had a laser on it. I don't know exactly what it was. It was shaped like a gun.
Then there was a laser sight on.
Yes,
What color?
it was red and it hit me in my left eye.
Well, then what happened then?
So when we got to Calder and MLK Street at the light, we got stopped by the light. He pulled over on the side of us again. And he was ranting and raving again. I didn't know what he was saying because I did turn my music up whenever the incident happened on MLK and Franklin, past MLK and Franklin. And whenever the light turned green on Calder, I kept on going. And whenever we got to the light on MLK and the I-10, that's whenever I seen the laser again. And the resemblance of a gun.
Now then what happened?
So that's whenever I took the feeder road as well as he did.
No,
Yeah.
you went after him.
Yeah.
Why?
I don't know. I mean, to be clear, like, I guess I was nervous. I was scared. I mean,
So you went
I don't
after
know.
him thinking he had a firearm, you have kids in the car, and so you followed him?
I'm not necessarily. I should.
That's exactly what you're saying.
I wasn't trying to.
You could have gone anywhere else, but you decided to follow him. You can get your your family in harm's way when you could get out of harm's way. You put them in harm's way.
You did that? I think that's where probation or mediation come in versus punishment, because he does have a wife and 3 kids that he's taking care of. He's been in jail for. He has, I think he has remorse.
Yeah, so I'm fully remorseful. You know, I don't even want to own a gun no more.
How many times did you shoot at him?
To my knowledge, 3 to 4 times.
Were you shooting at him or at his car?
At his car. I didn't necessarily aim just directly at him.
So if you're driving a car and somebody shoots at your car, they can say, I wasn't shooting at the driver, I was just shooting at his car. That's going to make you satisfied?
Also, I was scared, like I said.
With your children in the car, he was no longer a threat to you. You chased him down. I mean, right? You made a conscious decision to either go after him with the kids or turn away and get out of harm's way. If your story is true,
Yes.
but you decided to put everybody at risk. Your family that you love so much,
And I will
that you're
fully
supposed to
regret
care
that.
for them. Huh?
I regretted it every day since I've been arrested on this charge.
I would
I've been in jail.
The judge is locking on to pursuit. You followed him. Because even if the earlier threat was real, chasing turns you from escaping danger into re-engaging danger. And with kids in the car, that hits the court like a freight train.
I know the court might consider shock probation,
Yeah.
but with an affirmative finding a deadly weapon is not eligible.
Here's the other thing about it. The victim says there are 5 bullets in the car, 5 bullet holes in the car. His story is still not even close. It's 3 or 4.
In a situation like that, you can lose track of how many times. I think that there are 5, and he shot 5. You confess that you shot 5 shots.
Yeah, if there's a problem.
Now it's 5. Is that your final answer?
It could be 5.
It was 3
Yeah,
or
it
4
could-
a
it
little
could
while
be
ago.
5, yes.
The story evolves
Well, Your Honor,
as you're standing there.
in the context of a shootout, people lose track of what's going on. Time compresses. I'm just trying to.
Jeez.
Where
As
there
though
was
I've never been in one of
a
those.
gunfight in a car.
Yes, I know how that exactly works, sir. Anything else?
We're asking for probation, Your Honor. As I said, he can't get shock probation.
How much time does he get credit for?
But for the deadly weapon finding, you can be eligible for shock. He's been in jail 4 months. You could get 6 months upfront time. But I really think this person is a good candidate for probation. He has genuine remorse. I know he feels bad. He has a wife and kids that are there to support him. And in the heat of the moment, he made a bad decision. And again, you can look at his criminal history. He doesn't have any
How long have you been
history.
in jail?
Since the day before September 30th. I was booked in at 10:30 p.m. on September 29th.
How many cases?
I'm sorry.
140 days.
And how many cases do we have in here where the state comes in with write-ups from the jail where they've been disciplinary problems in jail? I mean, he hasn't, in 4 months, he hasn't got a write-up.
They seldom do.
Well, that's not been my experience lately. They get write-ups all the time.
We're
People,
gonna start keeping a score. I've been doing this longer. I'm here more than you are. I know when they produce write-up.
well, maybe
It's not that often,
next
sir.
door that I'm dealing with write-ups and people all the
I
time.
don't
I'm
think
sure if
these, I don't think these people are irresponsible.
if he had gotten in trouble in jail, he would be there. But it would make it.
Anything? Anything else by anybody? Okay. Nothing further, Sam? All right. If not, I'm going to find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence in the record supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt, and I find you guilty beyond a reasonable doubt of this aggravated assault with the use of a deadly weapon. The fact of the matter is that this court is going to have to has two different stories, two different versions of the events. But at the end of the day, the victim has 5 bullet rounds that you shot into his car. I don't see any on your car. You had the opportunity with, of all things, your family in the car to turn away. You did not. You turned into harm's way. I don't know if it's rage or what it was, but you went after him and shot at him. And he's the victim in this case, Mr. Sampson, strongly objected to you receiving probation. And I see your statement here. But this last sentence, your statement gets you. He turns on the feeder road. You turned on the feeder road as well. And that's when I pointed my gun and shot at him. And anyway, yeah, you were going after him at that time. There is enough evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense of aggravated assault. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for time you have served in accordance with this case. Also, the judgment will reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. This is a tragic situation. Could have been worse. We could be dealing with children dead and others. And everybody needs to, in difficult times, need to somehow stop, think, and appreciate what kind of tragedy can occur by the next choice you make. And sometimes with ego being the way it is, people want to go after issues that they perceive as trouble. Under your situation, the trouble had left, and you went and sought it out again. And that was the problem with the family. Oh, that is
Hey, is there a possibility of holding my wife goodbye?
it's the bailiff is in control of you now.
I love you. Love you. I'm gonna call you.
We now call 25 CR 519, the state of Texas versus Joshua Guidry. You are Mr. Guidry.
Yes, sir.
Present with Ralph Kindler, your attorney and the state's attorney. There is a first amended motion to revoke probation that has been subsequent to an original motion that was on December 9th. And then this first amended is filed January 28th. About 3 weeks ago, two to 3 weeks ago. What are we doing today?
He's gonna, if the court could go through the entire appeal and pleadings and requests.
First amended motion to revoke, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth and nothing but the truth, so help you God? Lower your hand. Does he waive a formal reading of this? Can we proceed in summary?
So,
In summary, this first amended motion to revoke unadjudicated probation states that on August 7th, 2025, that in this court you were placed on 10 years deferred or unadjudicated probation for assault on a peace officer. Is that true?
Yes, sir.
And that was a second degree felony, and you were placed on 10 years deferred or unadjudicated probation. Was all of that true?
Yes, sir.
Allegation. There are 9 violations. We haven't done this one as
No,
we hadn't had. One state you committed the offense of public intoxication on or about October 10th, 2025 in Jefferson County. True. What is he? Let's
He's
just
not
say.
pleading anything evidently. I don't know why we're going through this.
I think we've discussed it with him. I just want to make sure he knows.
Is he going to plead untrue to the indictment?
No.
To the
Not
motion?
the entirety.
What? Okay, tell me.
We have to go through it. I don't remember if it was the administrative violations that we were going to.
Okay, none of the substantive.
None of the substantive.
Okay, so the first 4 are crimes: public intoxication, PCP possession, public intoxication, and then number 8 is public intoxication, and 9 is public intoxication.
We were going to plead true to 5, 6, and 7. And then request for bond and have an updated pre-sentence report and give the state an opportunity to prove up the other allegations. I don't know what the problem is with that. I mean, what,
Nothing except that he's just pled true to violating conditions of probation, which would be the same conditions he'd probably have as a bond. So why does he need a bond?
he's entitled to bond because it's deferred.
Well, it would be, but you just pled true to some allegations, so the judge can decide. He doesn't have to give him a bond after he's pled true to those. He could actually revoke him, send him to prison right now.
If you don't want to get an updated PSI, they can proceed on the administrative violations.
What do y'all want to do?
I would plead true to the administrators and request a bond. If Mr. Laird doesn't want to attempt to proceed on the substantive allegations, we can
Oh, we were
start the hearing today.
We were set for an announcement today. You want to set it for a hearing? We'll set it for a hearing. We'll have a hearing.
I'd like him to have a bond.
I know.
Anything.
Well,
Yeah, I'm just trying to simplify things by going ahead and pleading to the administrative violation.
that's not simplifying things. It just, all it does is just makes it where you've got 3
Okay,
allegations.
what we're going to do is, we're not going to take it in installments. We're going to do it all or nothing. Let's set this for a hearing. When can y'all be ready for a hearing? 2 weeks?
Yes, sir.
Could he
2
have,
weeks.
could he have a bond for that?
And on the bond, the court is reviewing, what does he have now? Is there a bond?
There's
set now? Huh?
There's a bond.
In Mr. Guidry's case, Mr. Guidry, you know how many times you've been convicted. I mean, it's your life, right?
Yeah, but the PCP,
No,
No, that's what you're charged with. Here, phencyclidine possession. We're going to postpone that to another time. Talking about your criminal history. You know what your criminal history is. Okay. How many convictions do you have?
three,
12.
conviction, you wouldn't.
How could you know your life better than me? We go back to on 2011, failure to identify, giving false or fictitious information to police. You were convicted of a misdemeanor and confined. It looks like 4 days and probated for 6 months. In 2012, you were placed on deferred probation for 3 years for illegal possession of a controlled substance. Later in 2012, you were convicted and sentenced to theft, a class B misdemeanor, and I'm not sure what the confinement is. I can't read it very well. In 2015, convicted of manufacturing or delivering a controlled substance and given 7 years probation. And in 2020, misdemeanor of DWI, convicted and sentenced to 90 days. 21, Class A misdemeanor, resisting arrest or search, convicted, and it looks like 10 days in your confinement. So that was Class A misdemeanor. Then a DWI, 30 days in jail in 22. Convicted, sentenced to 6 months in the state jail for illegal possession of controlled substance. 23, convicted, 20 days confinement, harassment of Class B misdemeanor. In October of 23, state jail felony, 6 months for illegal possession of controlled substance. In January of last year, 25, Class A misdemeanor, resisting arrest, confined for 30 days. And then in March of last year, second degree felony, assault on a peace officer, and that's when you get this 10 years deferred or unadjudicated probation from me. So 12 times, and you've been handled, and you're currently on deferred or unadjudicated probation. You were convicted of all the others. Your criminal history is terrible. And now you are alleged to have committed drug offenses, public intoxication, etc.
Well, again, my suggestion was pleading to the administrator. You can get an updated pre-sentence report and come back for sentencing.
State
He's got new offenses. I mean,
wants
why
to
don't we
handle
skip
that.
those?
We're gonna have
Why would we skip
a hearing on all of it.
Because then we get.
Your bond is $250,000. Plus, if you post a bond, you're gonna have a DPS class. That's a condition of
I
bond.
suppose you're, this wouldn't have an updated PSI. What do you
Then we'll have a hearing
But
in 2 weeks.
We'd have to get an updated PSI before the sentencing.
Maybe. We'll see what happens. We'll see how that shakes out.
All right.
Okay, thank you. Larry Johnson.